Nobody would ask the question why. Of course, language barriers exacerbate these problems because in urban areas, lawyers are expected to speak Hmong, Spanish, Korean, different dialects of Spanish, and that further complicates the right to counsel. The other thing we found is that when counsel actually is appointed, he or she is not appointed at the right time. As Ellen talked about dispositions and detention, the Gault case only talked about the right to trial, the right to counsel at trial. And if you look even at the statutes, but mostly at the practice, you find that very few people are appointed counsel when they most need it, at the very first hearing. In Maryland, again, I'm going to use Maryland and Pennsylvania because they were the first ones that I read in the newspaper out of the 14. 93% of the cases observed in the Maryland study found that counsel was appointed at the trial. Not at the detention hearing, not at some time in between, but at the trial. Other states had the same situation. When the counsel and the child finally got together, oftentimes the judges would induce or encourage children to waive their right to counsel. This is not just Maryland, it's state after state after state. If you read at the waiver cases and adult cases, you see that the courts are very, very reluctant to permit adults to waive their right to counsel. This is complicated business, right? We spend, $1 million to get our law degrees. It's not easy stuff. And yet, the courts in juvenile court seem to think that waiver of counsel is the right thing to do. Again, in Maryland, 40 to 58% of children charged with crimes waived their right to a lawyer. 90 to 95% did so in Louisiana. 50 to 75% did so in Florida. Georgia, Ohio, and Kentucky all showed over 50% of the cases children waiving their right to lawyers. So what are the reasons? Well, some of it is financial, but as we said, what the assessors found was that judges directly or indirectly pressured kids into pleading guilty. And lawyers were often complicit with these waivers, but more often than not, lawyers were not even present with the discussion as to whether lawyers should be waived or not. So you found children discussing their need for a lawyer with their parent. You found children discussing their need for a lawyer with their probation officer. You found children discussing their need for a lawyer with the judge. All three of those people have other interests, right? Parents have financial interests. Judges or probation officers believe in services, whether the kid is guilty or not. Judges have efficiency concerns and also believe in the best interest standard. In Washington, and so the conversations, even when you're in front of a judge, are really not so good. In Washington, 69% of the cases where waiver occurred, judges failed to discuss the voluntary nature of waiver. Judges neglected to mention that lawyers are appointed regardless of the ability to pay in 72% of the cases. The right to trial was not mentioned in 79% of the cases. I think this is all from Washington State now. 24% of the cases, the judge did not even ask the child whether they really understood what he or she was talking about. In Kentucky, the defenders believe that the judge's colloquies concerning waiver are totally ineffective. Same thing in Indiana. Two-thirds of the people in Indiana, two-thirds of the lawyers believe that children never really understand what they're doing when they're waiving counsel. In Florida, the probation office informs the prosecutor when they think the child needs a lawyer. In Virginia, the judges will only appoint lawyers if they think the case is serious. Now, how a judge would know at the beginning whether the case is serious except by the charge, I don't know. In Indiana, 25% of the children just discussed it with their parents. It goes on. This is just depressing. The children themselves, of course, don't know any better. In Kentucky, the children claim that they waived counsel because they didn't think anything serious would happen to them. They didn't know that for Gerald Gault's little phone call, you can get 6 years in jail. In Ohio, plea agreements were worked out between parents and prosecutors before they even called the lawyer into the situation. In almost every state we found, the waiver was taking place without conversations with the lawyer. So let's assume that we do have a lawyer. What would we expect that lawyer to do? Judging quality is very difficult. You know, quality lawyering is a little bit like pornography. You know, when you see it, describing it is very difficult. Some people are just innately talented. Some people are young and new, and in our business, most of the lawyers are new, and they're going to get better as they get older, hopefully, and so the first clients are their experiment. On the other hand, some of us who have been there for so long have become so jaded and cynical, we might have been good at one time, but we're not anymore. Personal styles matter, resources matter, a lot of things matter in determining what makes a good lawyer or not. But the most we can say, and I have to say, if you look at the ineffective assistance of counsel lawyers, you find out what's bad, you don't necessarily find out what's good. But I think if you looked at all of these standard-setting groups, you'd find that at a minimum, lawyers' quality is determined by looking at the various tasks that the various standards groups and bar associations and rules ask us to do. And then we conduct a subjective analysis of whether they're doing those in the way that we would expect someone who was good would do them. The McCoy Report is another place where we look to see what the standards are. Well, what did we find? We found, first of all, as I said earlier, when lawyers are appointed, they're not appointed at those early stages. So you can't develop the trust relationships. You don't get a chance to find witnesses early. You don't get a chance to make those pre-trial detention arguments which are so critical to the ultimate finding. We all know, those of us who practice know, that if you're locked up pre-trial, you have a heightened risk of being locked up post-trial, right? So that first decision is very, very critical. A lot to talk about, and as I said, fortunately we're publishing all this with greater detail. But let's move away from all those things that don't happen so well at the beginning and look at what happens when the lawyer actually gets the case with some time to work. In Maryland, defense lawyers routinely meet their clients before the trial at the courthouse. 90% of the juveniles interviewed that they didn't even know their lawyer's name, and that the lawyer never visited them. In Indiana, over 1/2 of the children interviewed felt that they didn't have adequate time to consult with their lawyer. In Maryland, counsel did not investigate the underlying facts, let alone the education, mental health, and other history of their child. In Virginia, the majority of defenders are not in contact with their clients and do not perform the necessary investigations. In Pennsylvania, 99% of the lawyers interviewed said they never file motions or rarely file motions. They also rarely request exhibits, photographs, or other information about the identification in the case. In Texas, they said, well, the prosecutor is going to give us all the information. What more do we need? What do we need? Well, it doesn't take a whole lot of thought to figure out what else you might need. In Louisiana, there was almost a complete lack of investigation. In Georgia, defense lawyers rarely conduct investigations, visit crime scenes, or track down witnesses. In Kentucky, 1/3 of the lawyers interviewed did not meet the client until the day of trial. So why does that happen? Well, one could say one of the reasons it happens is that everybody pleads guilty anyway, right? In most American jurisdictions, the number of pleas far exceed the numbers of trials, but that's not good enough. That is just not good enough. The codes of professional responsibility say that is not good enough. Just because your client says he did it is not the answer to an American trial, right? The American trial's answer is, can the government prove that he did it? And just because the government claims they have the evidence to prove that he did it, you can't believe that anymore, right? DNA evidence, 200 people have been exonerated after eyewitness identification. What's interesting about those exonerees, 40% of them had positive identifications by the 40%. If you have DNA, you can sometimes prove that. If you don't have DNA, you better have a lawyer who knows how to cross-examine an eyewitness, or your chances of conviction are high. How about confessions? All our kids confess. Miranda be damned. They all confess. Well, interestingly enough, in those DNA cases, 25% of those